Ladies and gentlemen, the story you are about to hear is true.
Very much.
Next is number 33, State of Maryland versus Patrick Joseph Thomas.
Good morning, and may it please the court. Carrie Williams on behalf of the state of Maryland. In the midst of an opioid crisis, with overdose deaths at epidemic levels, and drug dealers routinely and surreptitiously mixing heroin with the far cheaper and deadly fentanyl, selling 4 bags of pre-mixed, pre-packaged heroin to a desperate addict is every bit as grossly negligent as competing in a drag race on a public street or participating in a game of Russian roulette. Patrick Thomas sold 4 bags of poison to Colton Matrey. Thomas did not know the composition of the poison. He didn't know whether it was just heroin, heroin mixed with fentanyl, or straight fentanyl substituted for heroin.
Do we know anything now about what it was that he ingested?
No, well,
Colton, I guess his first name is, or was.
Colton Matrey is the name of the victim. And we know that he died of free morphine intoxication. We don't know whether it was mixed with fentanyl. I'm assuming that it was not. It doesn't matter, because my argument is that in the midst of this crisis, in the environment of today, anyone who sells pre-mixed, pre-packaged substance that he or she believes is heroin has no way of knowing whether it's heroin, heroin mixed with fentanyl, or straight fentanyl substituted for heroin.
Just a question to clarify the record. Was there also a conclusion that alcohol intoxication was part of the cause of death?
The cause of death was alcohol and free morphine intoxication. For the causation argument, it does not matter. The morphine intoxication does not need to be the sole cause of death. I will note that the ethanol in the victim's heart blood was 0.08, so there was not a significant amount.
Ms. Williams, while we're on the topic just generally about the opioid crisis, hasn't the General Assembly passed subsequent legislation to attempt to deal with some elements of that? The legislation wasn't referenced in either brief, so I was wondering if there was any perspective that you had on subsequent legislation.
So there was subsequent legislation passed to increase penalties for persons who distribute fentanyl or a fentanyl mix. In the state's view, that's irrelevant to the issue here because the state has the right to use every arrow in its quiver when it comes to tackling the opioid crisis. And if the state can prove that a defendant was grossly negligent in his behavior and that gross negligence caused a death, the state has the right to prosecute that person for involuntary manslaughter. So that policy decision about prosecuting dealers for involuntary manslaughter when the people that they sell the substance to ultimately die of a drug overdose is another way that this can be combated. So yes, there was subsequent legislation. That's certainly in the General Assembly's prerogative, but that, in the state's view, is irrelevant to the issue here.
Does the quantity of the drugs sold or transferred affect your argument one way or the other?
It does, only to the extent that it's the state's argument that Mr. Thomas knew that the victim in this case was a desperate young addict. He sold him 4 bags of heroin, and as the court In Iowa, referenced in State versus Miller, cited by my friend on the other side, it's reasonable to believe in those circumstances that Mr. Matrey was going to use all of the drugs he was sold immediately and without moderation, because he was clearly in a desperate state of addiction. The record indicates that he called Mr. Thomas 27 or 28 times in about 25 minutes and texted him 5 times in an attempt to get his hands on the drugs that Mr. Thomas sold him and that ultimately killed him. Because...
So let me stop you there. If we did not have evidence that he was in a desperate state when he was attempting to contact Mr. Well, it's confusing, Mr. Thomas, we shall say, would your argument be different?
No. As with any gross negligence analysis, every piece of circumstantial evidence is important, so that's why the state points out that the victim was desperate, that he was a young heroin addict. I think that that is a piece of the state's argument. It's not dispositive. The state's argument is that anyone who sells pre-mixed, pre-cut heroin in the midst of this crisis, where even the Court of Special Appeals in footnote 9 of their opinion acknowledge that most heroin now has fentanyl in it, then that is in and of itself exhibiting a wanton and reckless disregard for human life.
So,
Well, I'll ask one more question, then over to you, Judge McDonald. So if we have exactly the same situation, but it was before the opioid crisis came to light and has really blossomed, that's a kind word to describe the nature of this crisis. Again, would your argument be the same?
Now, then it might be a little bit different. There have been courts, and some of them as far back as the 70s, who have held, Cruciani, a New York case that I cite in my brief is one of them, that did hold that one can reasonably conclude that the injection of heroin in unknown strength creates a high probability of death. The state doesn't have to make that argument here, and so isn't. But it is not unheard of that courts have found heroin alone is so dangerous and deadly that it in and of itself creates the possibility that the person who's selling it had a wanton and reckless disregard.
So you're not relying on sort of imputed knowledge on behalf of Mr. Thomas that this is a killer situation and I'm going to do it anyway. Imputed knowledge based on the opioid crisis.
Right, that is exactly what I'm relying on. That and the fact that Mr. Thomas is an experienced heroin user. He sold heroin frequently. He dealt in this poison. And in this environment, as the circuit court acknowledged, everyone knows what's happening in Worcester County. Everyone knows people are dying left and right of drug overdoses in this county.
Ms. Williams, the decision below seemed to focus on causation. If we accept your gross negligence theory with regard to the sale of the drug, do we have to get to causation?
Well, my friend on the other side concedes causation. He concedes that it is sufficient to prove grossly negligent causation. The Court of Special Appeals erred in finding that there was no causation. Their analysis was incorrect. So if this court does reach causation, I think it has to. I would urge this court to find that there was causation. Where the Court of Special Appeals went wrong, I think, is by assuming that because the victim injected himself with heroin, that somehow alleviates Mr. Thomas of responsibility. And that's not so. This court's and the Court of Special Appeals cases have shown that the defendant's actions do not need to be the sole reason for the victim's death. In the Palmer case, this court said that, and in that case, a mother was charged with grossly negligent involuntary manslaughter for the death of her child because she did not remove the child from the reach of the boyfriend who inflicted multiple violent beatings on the child. So she was not the direct cause of the child's death and was not the sole cause of the child's death. But this court said that doesn't matter. Her behavior was grossly negligent. Her behavior caused the death of the child, and she's guilty of involuntary manslaughter.
Was that because she was in a custodial situation?
That's right, but in that case, the court was relying on an omission and here we have a commission. So there was a duty in Palmer, but Palmer isn't the only case that makes it clear that a defendant's actions do not have to be the sole cause of death. Goldring is another case that I actually think is very similar to this, to the fact pattern here, although certainly, albeit analogously. Goldring is the drag racing case, where Mr. Goldring engaged in a drag race with the victim. The victim lost control of his car and died, and Mr. Goldring was prosecuted for involuntary manslaughter because the court said he engaged in such a grossly negligent activity with the victim that he should have, that it was wanton and reckless disregard for whether anyone lived or died. No,
Excuse me,
please.
I'm sorry. Earlier, you had said anyone who saw a drug like this with this result could be prosecuted for involuntary manslaughter. I guess my question is, what if the state identified the supplier in Delaware that Mr. Thomas obtained the drug from? Would that person be prosecutable for the same involuntary manslaughter?
I think so. I think that at some point we have a causation problem. We have a proximate cause problem. But this court has been dealing with those on a case-by-case basis, and courts everywhere have been dealing with those on a case-by-case basis since we've had to decide how many houses that burnt down get to sue the Long Island Railroad because a spark flew from the locomotive. That is nothing new. That would be decided on a case-by-case basis, and we don't have to decide it here because Mr. Thomas himself admitted that he sold drugs to the victim directly.
Ms. Williams, the Court of Special Appeals also seemed to punt on whether it was a malum in se or a malum prohibitium.
Correct.
Is that something we need to reach?
No. My friend on the other side argues that if it's a malum in se crime, it cannot support a grossly negligent manslaughter conviction. Respectfully, that argument doesn't make sense. Because if a defendant's actions are grossly negligent, they're grossly negligent. The idea that defendant's actions have to be lawful in order to support a grossly negligent manslaughter conviction is what Judge Moylan called the semantic fallacy of the false affirmative. Lawful conduct is not an element of grossly negligent manslaughter, just as an absence of malice is not an element of grossly negligent manslaughter. So from the state's perspective, we don't care whether distribution of heroin, quite frankly, is a malum in se or a malum prohibitum crime. In this circumstance, Mr. Thomas did that grossly negligently with a wanton and reckless disregard for whether his victims lived or died, and that's sufficient.
Well, I understand, but we could find both. We could find unlawful act and grossly negligent.
I think the problem with unlawful act, and you certainly could, and I'm not going to try and talk you out of it too much, except that one of the causation elements for unlawful act involuntary manslaughter is that the death had to occur during the commission of or the escape from the unlawful act. And here, quite frankly, it's pretty clear that the victim didn't inject the heroin until at least some time later. He was in his own home in his bathroom. So I think it happened pretty quickly after the sale because he really wanted to use the heroin, but it wasn't. The commission of the unlawful act, I think the state would have to, in good faith, concede, ended when the sale was completed, and the death didn't occur until after that.
Just out of curiosity, since you bring up the sale, under what circumstances did that occur? Did they meet on the street somewhere, or did the victim go to the home of?
So what I understand from the record is that the victim, as I said, called Mr. Thomas 27 or 28 times in about 20 minutes, texted him 5 times. The texts were, at least some of them were, call me, I got $30, I need 4, I'm here, yo, I'm here. Mr. Thomas said he didn't remember where he met the victim. He did meet him somewhere out in the world. He said it might have been the parking lot of a Food Lion, but he didn't remember. The victim had, just for purposes of clarifying the record, the victim had borrowed his mother's debit card and taken $40 out at 11:59, and the 27 or 28 calls happened between 11:45 and 12:07. So this was a short ramp up to the sale, and then it happened pretty quickly. With regard to the gross negligence, the Court of Special Appeals usurped the trier of fact's role when it concluded that the dealer's conduct was not grossly negligent because it can infer that dealers want customers to live so that they can buy more drugs. This is not proven by the record or in reality. The court also said that addicts have no rational interest in increasing the danger of what they do. That is also unfortunately not true. The opposite is in fact true. Overdoses kill 200 people a day, and there's been an increase in overdose deaths of 500% over the last decade. Dealers mix fentanyl with or substitute fentanyl altogether because it's cheaper and much, much more potent.
Now, was this developed in the record, or are we taking judicial notice of this fact, or are you asking us?
I think the court can take judicial notice of the environment. The circuit court below certainly acknowledged that everyone in Worcester County knows what a problem of heroin is. And in the record, this was a not guilty statement of facts, I'm sure the court knows, but just to remind you, it was a not guilty statement of facts. But the prosecutor said that Detective Jeff Johns would testify, if there had been a full-blown trial, that Worcester County was, quote, consumed with heroin overdoses, and that there was an acute awareness of the dangers of heroin. So one other reason that I want to make clear was not that the inference that heroin dealers want to keep their customers alive is not true, is because Mr. Thomas said that the best heroin out there when he sold the victim Banshee heroin was in fact Banshee heroin. What does it mean to be the best heroin out there? It means that it is the strongest heroin out there. Drug dealers want to get their customers as high as possible. They want to sell them the strongest drugs possible. They want to get them as close to death as possible without actually killing them. No one is arguing that dealers want to kill people, but they certainly don't care whether their customers live or die. And their goal is, in fact, to sell the most potent and the strongest drug possible so that their customers, if they don't die, will return. It is unreasonable, the Court of Special Appeals' conclusion that drug dealers want their customers to live is unreasonable. The Court of Special Appeals also said that every sale, that if the state's argument were accepted, that every sale of heroin would basically be gross negligence or involuntary manslaughter. The state quarrels with that a little bit because we've made some factual distinctions and pointed to some things that we think make this different than the average heroin sale. But be that as it may, the court says every sale of heroin would be gross negligence, which would mean criminal liability comes down to a mere fortuity, and that we don't apportion criminal liability based on bad luck. And to that I would say, yes, in fact, we do. We don't apportion it exclusively on bad luck, but certainly grossly negligent behavior does not always result in death. Goldring could have had a drag race where everyone had fun and no one was hurt and everyone went home, and he wouldn't have been prosecuted for anything. But unfortunately for Mr. Goldring, he had the bad luck of having his competitor lose control of the car and die. So he was charged with involuntary manslaughter. When there's a gunfight on the street and no one is hit with a bullet, no one's charged with any degree of homicide. If someone is unlucky enough to hit a bystander, then they certainly are charged with homicide. So I take issue with the Court of Special Appeals' criticism of the state's argument because it would result in criminal liability being doled out by mere fortuity. If there are no further questions, the state will reserve the balance.
A question. Was there any basis in the record at all for the Court of Special Appeals' conclusion that the drug dealers want their customers to remain alive? I mean, was this based on some?
No.
Anything?
No. And in fact, in the Court of Special Appeals' opinion, the court drops a footnote and cites an article that says that most heroin in the midst of this crisis is mixed with fentanyl. So no, it's not supported by any fact in the record. It's a conclusion based on the court's assumption about the way drug dealers operate.
Thank you.
Thank you.
All right, thank you, Ms. Williams. Mr. DeSimone? Good afternoon to you.
Good afternoon, Your Honors. May it please the Court, Mark DeSimone Jr. on behalf of Patrick Thomas. Your Honors, the issue in this case is not about fentanyl. It's whether distributing 4 bags of heroin identical in type and amount to that which Mr. Thomas consumed in one sitting 3 times a day, constitutes a willful and wanton disregard for life. It does not. For if it does, this court would have adopted a per se rule, as the state urges in its brief, to be short, and would have adopted per se manslaughter based on an overdose death. That is adoption of a rule best commended to the legislature. In the usual or run-of-the-mill heroin transaction, absent indicia of a special or unusual risk of death, that cannot constitute a gross, willful, or wanton disregard for life. This court made clear in Albrecht that the focus in a gross negligence manslaughter case is on the defendant's actions, not the results. And I quote, "Whether an accused's conduct constituted gross negligence must be determined by the conduct itself and not by the resulting harm." So we look at that transaction around 12:30 in the evening, June 26, 2015, the delivery of 4 bags of heroin. And this was precisely the heroin which Mr. Thomas used. He used 12 bags a day. He used 4 in one shot. He testifies, or would have testified, he said to police he couldn't have overdosed over what I sold him. I only sold him 4 bags. He would have testified at trial that he personally had used the same product, the Banshee heroin, had not overdosed, and obviously had not died from it.
Mr. DeSimone?
Yes.
What about the example or the analogous case that the state offers of the 2 drag racers?
Sure.
Certainly the one who didn't die, who was the defendant in the case, like the heroin dealer here,
Yes.
he was willing to drag race, and he
Yes.
did drag race, and he didn't die.
Yes.
Have the same situation with the heroin dealer. He
Well,
took the
and
same
then-
amount of heroin, and he didn't die.
Your Honor, I do not quibble, and I would agree that just dying or not dying is not what I'm proposing. What I would assert, Your Honor, though, is looking at the risk of life. And there's a critical difference in Goldring. My understanding of Goldring is that the vehicle used by the defendant was not registered and could not be registered because it would not meet the registration standards. It should not have been on the road. I might be confusing that with another drag race, but that did jump out in one of the cases I reviewed for this week. But I'm glad Your Honor asked, because the test I would propose, the result I would propose, fits very nicely in this court's jurisprudence with gross negligence manslaughter based on driving conduct. I would direct Your Honor's attention to this court's decision in Nast v. Lockett. It's not in the briefs. It's 312 Maryland 343. I disclosed it to Ms. Williams yesterday.
Nasty Lockett, right?
Nast v. Lockett, yes. This is Judge Orth for the court, and it was a civil case involving punitive damages back before Zenobia, when gross negligence was the punitive standard. And what Judge Orth's analysis was, we'll analyze this based on whether or not someone had died in the accident. Could it go to the jury on gross negligence manslaughter? Is the same analysis as for whether or not there should be punitive damages. And what the court's analysis is, in this case it was intoxication. Intoxication alone, the mere fact of intoxication, is not gross negligence. Even in driving, even in an accident where there is intoxication by the driver at fault. There is a sliding scale in this court's words where extreme intoxication reduces the state's burden as to other factors. As the degree of impairment increases, the need for other circumstances lessens. Conversely, the less the degree of alcohol impairment, the more the other conduct of the drinking driver needs to be extraordinary and outrageous. I would say that should be the test, and that is essentially the test in other jurisdictions with regard to drug distribution deaths. The mere fact that the distribution of drugs, and I shall be clear, not involving fentanyl, the mere act of the distribution of drugs alone should not.
Well, substitute drugs and use heroin.
The mere fact of the distribution of heroin alone should not.
And how do you know, and how does your hypothetical dealer know whether or not fentanyl is mixed in?
Well, Your Honor, I will say this. Mr. Thomas's statement to police is that, or would have testified at trial, that he personally had used the same product. So he knows by knowing what he has used it. He has used it.
But isn't the example that Ms. Williams gave us of Russian roulette, isn't that pretty analogous here?
No, and I will tell you why. And it might be analogous if it's a fentanyl case. Under what I propose, as the defendant does something with an increased and severe increased risk of death distributing fentanyl, it's that extreme action, that extreme increase of risk, which connotes the gross negligence. However, if that risky action is not present or does not come to fruition, there cannot be criminalization. Let me give you an example where there's a risk but does not impact. And I was working on an example, and of all things, I came up with a structure that lacks supports. Of all things, what were the bars?
Mr. DeSimone?
I came up with it recently.
Within, let's say, a moment.
Half hour. But but it made sense to me. And what were the diagonal supports called? I was thinking about gooser beams. Let us say that a structure was built without gooser beams.
Braces, actually.
Gooser braces.
And
And the failure to use gooser braces is dangerous because it creates a decreased stability. Let's presume that. And there's an accident. But the structure standing, what caused the accident wasn't stability. It was the failure to secure the load properly, or the failure to grip it. The structure's fine. It should have used gooser beams. It should have used gooser beams. And that was an omission. The gooser beams had no impact. That risk, although riskier, had no bearing on the accident.
So you're saying plain heroin, the pure heroin, not a serious risk to health?
Well, pure in terms of purity, absolutely not. But just heroin absent fentanyl, or another additive like fentanyl. Correct. Because
not a serious risk to life.
That's what other courts have held. In Your Honor, if this court was to adopt that, that would create strict liability under the view that just heroin distributed leaving the overdose, that would create strict liability. Under that standard, Your Honor, every distribution of heroin, regardless of fentanyl, leading to overdose, ergo, is gross negligence, manslaughter, ergo, next time will be depraved heart second-degree murder. The adoption, as other jurisdictions have held, the adoption of a strict liability rule is best commended to the legislature. Now, as between my facts, the facts of this case, and the ceiling, there's great room. As between the facts of this case and the floor, there's not much room. This is an arm's length transaction. It's 4 bags. It's what my client used on a thrice daily basis. It was not laced with fentanyl. I want to make clear, I believe Ms. Williams openly said the word fentanyl 6 times by my count, 4 or 6. It strikes me as a lot for a case that doesn't involve fentanyl.
Are you conceding that there's no issue of causation in this case?
That was very surprising to me, Your Honor. In the circuit court, the state made very clear it was proceeding on both theories of liability. And the circuit court found my client guilty under both theories of liability. I believe that's page 73 of the record extract. I challenged both theories in the Court of Special Appeals. My client's conviction was vacated under both theories, and on page 22 of the state's brief, they say that this case involves the first two theories, the unlawful act, the gross negligence, and omits the omission to perform an act. The fact that causation is not an issue in unlawful act would have surprised every actor in the circuit court. I will say, I think it's commendable they concede as the causation. On the causation aspect of gross negligence, I have not conceded, however, Your Honor, and I think the state's misread my brief. I challenge causation as to gross negligence. I have not asserted an argument as the cause. I'm sorry, pardon me, I misspoke. I challenge causation as the unlawful act manslaughter. I have not raised an argument as to gross negligence causation. I believe that the case that show my duty of candor is that it has a different standard. I have not raised that argument. However, the Court of Special Appeals did hold that there was no causation. I do not independently argue the lack of causation for gross negligence, but it would be petitioner's burden to show error in that analysis. I'm also very much human, and if my analysis is incorrect and the standards are the same, then I believe for the reasons argued in my brief, there was a lack of causation. But I do not assert a causation argument as to gross negligence.
Mr. Davidson, let me try and extend it a little bit further, just as a hypothetical.
Yes, Your Honor.
You're saying that the state would like this court to adopt a strict liability on a sale of, really it's controlled dangerous substance. It isn't just heroin, is it?
Precisely. I think it would apply to any controlled substance, yes.
As a gross negligence standard.
Yes, sir.
What we're talking about here is an overdose death.
Yes, Your Honor.
But if there's a gross negligence standard on the sale of a controlled dangerous substance, and instead of an overdose, there's a different, maybe somebody under the influence is involved in a drag race, or maybe they're just driving somewhere and cause an accident and there are deaths involved, would that gross negligence standard extend to involuntary manslaughter in issues that aren't overdoses?
If A distributes to B and B is in an accident and hurts and kills C, would A be liable for C's death? That would obviously be a causation issue, and the standard for gross negligence, my research is proximate cause. I could see potentially how there would be the specter. I think the dividing aspect would be proximate cause or causation from that. But certainly, I do think, I believe very strongly, Your Honor, is that one of the flaws in the state's position is that with drug distribution, it's not one action by one person leading to one result. With distribution chains, there can be multiple counts arising based on one result.
Which was Judge McDonald's question, and how do you respond to Judge McDonald's question?
I think that's taking away the interstate aspect of Delaware. I think there's multiple counts. If A distributes to B, who has independent distributors, to C, who shares with D, I think all of them are trafficking in heroin. And if the state is correct, if dealing in heroin without anything more is grossly negligent conduct, each under the state's theory would be liable. I think that's a big problem with the gross negligence per se aspect of dealing with this.
Do you agree that this amount of heroin, excuse me for scratchy voice, this amount of heroin could kill?
Could kill. Well, it has. I do not dispute that heroin is a lethal
You don't need it, it depends, if I'm asking you could kill.
Could kill, yes. With the caveat, Your Honor, with the caveat.
Wanton and disregard for life, that's the standard, right?
With the caveat, Your Honor, is frankly, as to a lot of these facts, they're not in the record. One thing that's been drilled to me as an appellate practitioner is my world is the record. Gosh, when these things out of the record that are exonerative, and I wish to say those things, I'm beholden to the record.
Well, there was a proffer by the state.
Yes.
It was incorporated into the agreed statement of facts. It was
And-
read into the record.
Yeah, well, yes, and if that's where Your Honor's going, what's interesting is what Ms. Williams read, but where she stopped that quote. The quote is as to page... Of course, it's on the last page of my notes. On page 58 of the record extract, Worcester County had been consumed with heroin overdoses, and that's where Ms. Williams' quote ended, so let me continue it. Had been consumed with heroin overdoses, some resulting in deaths. These overdoses have resulted in acute awareness of the dangers of heroin. Heroin kills and everyone knows it. The next page, the proffer of the expert. Anyone in Mr. Thomas's situation would understand the dangers of heroin and its propensity, this is important, propensity to harm physically, if not kill. Propensity to harm, the potential to kill. And that's why building on that flexible standard from Nass v. Lockett about a sliding scale depending on the degree of intoxication. Extreme intoxication calls for fewer other factors. Lesser intoxication or intoxication alone demands additional indicia of death.
But isn't that a factual question?
It's a factual
As to whether
precise.
the defendant acted in wanton and reckless disregard?
It's a factual question which must be guided by proof, Your Honor, and the proof is on the state. And I would direct, Your Honor, to what the courts in Iowa and Missouri, the intermediate courts of both those states, and the Supreme Court in Kentucky have required, and this would be my test, building on the Nass v. Lockett standard and building on the other states. My test requires proof of two things. First, proof that heroin consumption is probably, and I underscore probably fatal, but Kentucky qualifies as a substantial and unjustifiable risk of death, or what Missouri qualifies as a probability less than a substantial certainty. And the second is the proof that the amount distributed creates a risk of death. And I'll elaborate both using those cases.
And what does the proffer
The
made by
proffers,
the state say in that regard?
well, and they reversed the conviction because in Kentucky, as to the first, quote, there was no proof that an appellant or any other layperson should have been aware that there was a substantial risk that the decedent would die from ingesting these substances.
And in our
Missouri, yeah.
In our case, what does it say?
It says what I just said, Your Honor. Consumed with heroin overdoses, some resulting in death, propensity to harm physically. And I think the Missouri case is excellent in showing, Your Honor, why those facts would not be sufficient. Because what the Missouri case is that although a physician testified to seeing overdoses, she did not address, quote, whether or not the dose ingested by decedent created a known probability that decedent would die, and thus, quote, spoke generally about the inherent dangers of heroin use, quote, end quote. Ultimately, there was no proof, quote, that, quote, death by injecting heroin is a probability less than a substantial certainty. So what these cases look at is that whether or not heroin in the abstract, there must be proof that if one consumes this, it does not lead to death. In B, it must prove that once you've proven that it's fatal in the abstract, that the amount, the nature of what this shows will lead to a possibility, a substantial certainty of death. And I will elucidate with the cases applying these standards nationwide, because I know I anticipated one question would be, under your test, Mr. DeSimone, what would be sufficient? Well, A, not this case, but B, I can tell your honors what would be sufficient under the test that I propose. There's a case, Commonwealth versus Bowden, Pennsylvania in 1973, which is interesting because Pennsylvania enacted a statute, I presume in response, that said, that recognized that heroin is truly a dangerous drug, but also recognized that the injection of heroin into the body does not generally cause death. That would be the importance. And I would say Pennsylvania's adopted a statute. By my count, 15 states have done this statutorily.
Do you have a cite to this case?
Bowman is 456, PA 278. And in all candor, I found it recently. I haven't connected the dots, but I read the case 1973. And I do know it's in my appendix that Pennsylvania has a statute. 456, PA 278. What would be sufficient to show that this reckless disregard for life? I would point to State v. Randolph, with both parties citing the brief. The dealing in uncut and diluted heroin advised the purchaser this is pure, uncut, and dangerous. She had not had time to dilute it. And Randolph had a customer who overdosed 2 weeks prior. He stated, well, anytime you do that, you're subject to dying. People versus Cruciani, New York case. The defendant injected the victim with heroin, knowing she was visibly intoxicated, in his own words, quote, completely bombed out and could not walk or talk straight. State v. Voss, Missouri Appellate Court in 2016, where the person not only provided the substance, but suggested how much to use, prepared it by mixing it, drew it into the syringe, and thus, in the court's words, provided the toxin, provided the advice and technical support, helped manufacture the necessary paraphernalia for preparing the drug, and provided the expertise to load the device. Commonwealth versus Catalina in Massachusetts. The defendant advised the victim this was very potent stuff. She shouldn't fool around with it and should not do a whole bag. He distributes one bag, and says, do not do a whole one. He knew that she could not handle an entire bag, and he had helped the victim who had overdosed privately in reviving from an overdose.
Mr. DeSimone?
Yes, Your Honor.
Commonwealth versus Bowden is a 1973 case. Do you think that the courts and society generally knew as much about cocaine back then?
This was heroin, but heroin's been dangerous. I'll go back to your original question, Your Honor. And I understand Bowden was heroin as well. But I do not ignore, nor could we, that heroin's a very dangerous and lethal substance. The lethality is there. What the courts have said, and I'm looking at recent cases, 2015 and 16 in Missouri, in Iowa, 2000 in Kentucky, is that still it's incumbent on the state as part of proof to show the necessarily, not potentially lethal aspect, but the probability of lethality, and to elucidate that through the defendant's conduct. I'll focus on where I began, which is on Albrecht. You'll look at the conduct, not the result. And looking at the defendant in distributing this amount of 4 bags, is that enough to show a likelihood of death? We would submit no, Your Honors. Unless there's further questions, we ask that the Court of Special Appeals be affirmed. Thank you, Your Honors.
Mr. DeSimone?
Thank you. The dangerousness of heroin in 1973 is not the same as the dangerousness of heroin in 2015 when Mr. Matrey died, or 2018 as I stand here today. But even in the 70s, the New York court in Cruciani concluded, and my friend on the other side just cited some of the facts of that case, but the holding of that case was that one can reasonably conclude the injection of heroin in unknown strength creates a high probability of death. The same with Catalina, which is cited in my brief and which was also just mentioned by my friend. That's a 1990 case, but the court said in that case that heroin is dangerous. It creates a substantial likelihood of death because 225 to 315 people died last year in Massachusetts of a heroin overdose. 469 people died in the first 6 months of 2018 in Maryland.
Ms. Williams, does your argument depend largely on the fact that what was distributed here, sold, was itself a criminal act? The distribution of something that is, a CDS.
It does in this way. My friend mentioned gold ring and that the cars in that case had been modified for speed, and
Well,
that's
I'm thinking,
true.
for example, to interrupt you only because of the interest of time. A legitimate sale of a handgun, legitimate sale. We cannot, any of us in this room, disagree that it has the potentiality of lethality. No gross negligence in the sale of that, right?
In and of itself, no, because the degree of foreseeability of death in that situation doesn't rise to the level of gross negligence. Now, if you, the legality of this transaction would be questionable, and my argument doesn't rise and fall on that. But if a person sold a handgun to someone who professed suicidal ideations, said, I'm going to take this handgun and I might go home and shoot myself with it, that might rise to the level of gross negligence. Even though it was a legal transaction, let's assume for the sake of argument, if the seller had reason to know that there was a high probability that death would result from this sale, yes. But I mentioned gold ring and the legality of the cars, or whether the cars could have been driven legally on the road for this reason, and I started to answer Your Honor's question that way for this reason. There is no legal heroin. There's no heroin that you can go buy at the grocery store and be reasonably sure that you're going to get 25 milligrams of heroin and 99% inert materials when you take that dose of heroin. There's no federal regulations that governs the potency of heroin. There's no governing body or corporation that has a reputation to maintain that ensures that the quality of the heroin that you're purchasing and then distributing is of a kind that's not going to kill somebody. And so for that reason, I think it matters that it's illegal, not necessarily because it's illegal, but because that Mr. Thomas and no one who sells street heroin has any idea what's really in it.
Okay, so it's really that you don't have any idea what's in the heroin?
That's correct. Now that is a product of the fact that it is unlawful and it's a black market item, but it is not, that is just a byproduct of that fact. It's not an element.
Okay, refresh my recollection on a small point, well, maybe not such a small point, but do the agreed statement of facts include the number of bags that Mr. Thomas sold?
Yes, 4. Mm-hmm.
And all 4, the contents of all 4 were consumed?
That's right.
Based on what we learned autopsy, or is it circumstantial evidence?
It's circumstantial evidence. How we know is that there was an empty bag in the victim's hand and 3 more empty bags on the floor.
Okay.
Do we know how much heroin was in each of the 4 bags and cumulatively how much there was?
We were able to infer that, and it is escaping me, unfortunately.
I was thinking you might have been able to infer it because there was in the statement of fact something along the lines, there was 13.10 grams in the 60 bags.
Right, that's correct, yes. So we can get there with math, but I can't, standing here, I apologize, remember what the total amount of the 4 bags were, but there was testimony about how much a bundle, there are 10 to 13 bags in a bundle, and
13.1 grams.
Thank you, Your Honor. 13.1 grams. So I wanted to make sure to mention not only that the Bowden case was 1973, so that I think it is much different, but the Missouri case that my friend mentions, the Shell case, that case required knowledge that death was probable, and I don't think our gross negligence standard rises to that level. I don't think that we needed evidence in Goldring of the probability that one of those cars was going to crash and kill somebody. We looked at Mr. Goldring's behavior, and we decided that that was grossly negligent. It exhibited a wanton and reckless disregard for the consequences of his action without regard to the probability, mathematically speaking, that someone might die. And it's the state's position that selling poison, the composition of which is unknown because it's unregulated and it's unlawful, and it is pre-mixed and pre-packaged. But what is known is that that poison, in some aspects, is killing members of the community left and right. Evinces a wanton disregard for whether the people that the defendant sells that poison to live or die. That's gross negligence, and if the sale of that heroin or heroin and fentanyl or fentanyl alone causes death, then the defendant is guilty of grossly negligent involuntary manslaughter.
Is fentanyl a killer if consumed even in very small amounts?
Yes, I believe so. Which is why it's the fact that fentanyl is being mixed with heroin surreptitiously is so dangerous.
But Mr. DeSimone is correct, there's no fentanyl involved in this case.
No, and the state's position is that doesn't matter because Mr. Thomas had no way of knowing whether that was true or not. And I did want to make the point that Mr. DeSimone mentioned that Thomas consumed the same amount that he sold the victim 3 times a day. That is true. The victim in this case, however, was younger and more inexperienced, and there is no evidence that Mr. Thomas consumed the same, from the same bundle or the same package on the day that the victim died. So the idea that he knew that it was fine because he'd used it, in the state's opinion, doesn't hold water.
So my questioning will end with the same question with which I began. The vulnerability of the victim, you believe, is relevant here?
I do. It's to the extent that Mr. Thomas knew the vulnerabilities, certainly. That goes to the foreseeability of death.
But the vulnerability really doesn't matter in this case based on the standard that you want this court to carve out.
That's correct. The state,
which is a carve out that any sale of heroin is grossly negligent.
well, the state would certainly start with that position, but its second position would be any sale of heroin that was mixed and packaged by someone else, such that the person who's actually distributing it has no idea the composition of that heroin. That would be the state's second tier position. And then the third tier position, just to be clear, is that there are also distinguishing factors that the state points to in our brief that make this sale different than some other sales that might not, if this court decides that, might not be as dangerous.
And those are the vulnerability factors.
The vulnerability factors, the desperation, which I suppose you could characterize as a vulnerability factor as well. Thank you.
All right, thank you both.
Your Honors,
Oh, do you have a?
this is highly irregular, but my colleague has several additional minutes. If I could have 10 seconds, in the court's time for a correction.
It is irregular. I say no.
Thank
Very
you.
well argued on both sides, though.
It was very well argued.